Good morning and welcome to an oral arguments session of the 5th District Court of Appeals. To my right is Judge Orfinger, who will be sitting with us today, and to my left is Judge Torpy. We have 4 cases scheduled. They are all civil cases, so each side will have 20 minutes. If the appellant wishes to reserve time for rebuttal, let me know and I'll try and help you out with that. Let me ask you to do something for me, and that is if you have any kind of a device which has an on-off switch, turn it off, unless, of course, it's something like a hearing aid, in which case that's fine.
Pacemaker?
Pacemaker be okay, too. With that in mind, let's begin by calling the first case, PAULA SZLASA versus Gary S. Borders.
Good morning. May it please the Court. I'm James Lynch on behalf of the appellant, PAULA SZLASA, and what we're here about today, Your Honor, well, first let me state that I would like to reserve 5 minutes of time for rebuttal in this matter.
All right, the yellow light will come on at 5 minutes, and I'll try and remind you in any event.
Thank you very much, and I think I have a timer right here, too, that'll help me. What we're here about, Your Honor, is that we believe that the trial court erred in allowing a negligent or an intentional tortfeasor to be placed on the verdict form. To start off my argument, versus getting into the facts, I know you all have the briefs.
Yeah, let me guide you to where the trouble part is, Mr. Lynch. I think, but for one thing, I suspect your argument would probably be correct. Help me with understanding why this factor doesn't otherwise cause a difference. The jury found no negligence on the part of the Sheriff's Department. I guess I don't understand what difference that a Fabre defendant would be if no negligence was found.
Thank you, and I can address that. First of all, we used the standard verdict form, which says was there negligence on behalf of the Sheriff's Department that was a legal cause of injury or loss to the plaintiff, PAULA SZLASA. There's twofold argument to that. One is it the question asks not only about negligence but also about causation. So therefore, the cause of this accident, I think if you have the intentional tortfeasor on the verdict form, clearly the jury can reach the conclusion, yes, the sheriff was negligent, but the cause of the accident was a result of the cause of the injury was a result of the actions of Robert McLeod, who was allowed to be placed on the verdict form.
Well, they had to start with question 1, right?
Yes. But that's what I'm saying, that is part of the question.
The court instructed them that if you answer question 1 no, then, I see what you're saying. You're saying that because question 1 was a compound question.
Yes, Your Honor.
That they could have answered no, meaning that it wasn't the legal cause. That's
correct, Your Honor. That's the exact point that I'm making. And the second thing is...
Well, is that the same as saying, though, that the intentional tortfeasor is 100%? I mean, if you assume that theory, 100% the cause and that the sheriff is 0% the cause? That's
something that we don't know based upon the question. And the second thing is, Your Honor, the other point would be that having the negligent or the intentional tortfeasor on the verdict form itself is in and above so prejudicial and to our case in that who knows what the jury considered if they consider the intentional tortfeasor the legal cause of the loss or even 100% negligent when they shouldn't have been on the verdict form in the first place. I think that if there were, for instance, if we had them fill out that the Sheriff's Department was 0% at fault and then that the negligent or the intentional tortfeasor was 100% at fault, then I think that would be somewhat of a different issue.
Maybe I'm not understanding the compound question thing. I'm reading the question. It says, was there negligence on the part of defendant Chris Daniels in his official capacity as sheriff, which was the legal cause of damage to plaintiff? Where's the compound part of that?
First of all, the negligence, and then the legal causation.
Oh, I see what you're saying. All right, now I understand.
Yeah, that's what my argument is for that, Your Honor. And so therefore, that's I understand that being that they did check no to the first question, but the second the second part of that, in addition to that argument, is that having the intentional tortfeasor on the verdict form is kind of like having an 800-pound gorilla there. I mean, that's the person that, was fleeing and eluding, running through the stop signs.
Well, let's talk about intentional, whether it's an intentional tort or not. Which intentional tort is it?
Okay. Here's, Your Honor, and that's actually the main issue that's brought up by the FDLA amicus about the Amario case, the Florida Supreme Court case, that addresses the definition of intentional tort. And it's really a matter of degree. In that case, they found that just drinking and driving in and of itself is not an intentional tort. But what the Florida Supreme Court stated is that where a reasonable man would believe that a particular result was substantially certain to follow, he will be held in the eyes of the law as though he had intended it. However, the knowledge and appreciation of a risk, short of substantial certainty, is not the equivalent of intent. Thus, the distinction between intent and negligence boils down to a matter of degree. Apparently, the line
is that a question of law, or is that a question for the jury to decide?
See, I think it's a question of law, Your Honor, because that goes to the point of as to whether that intentional tortfeasor is put on the verdict form or not. I mean, the judge made the decision.
I'll tell you, counsel, I've seen this argued in a different context, like as to whether or not there's insurance coverage for a loss and, things like that. And you very often see plaintiffs argue that it's a question for the jury. It's a question of fact. You don't see them argue that it's a question of law. So you say that the court should have, as a matter of law, decided whether or not the conduct of Mr. McLeod was negligent as opposed to intentional.
Yes, and essentially that's really what it boils down to. If the court ruled that his actions in and of itself were just merely negligent, then according to Fabre, that person should be put on the verdict form. But if you look at the cases that the actual cases that we cite with respect to not putting them on the verdict form, the Merrill Crossings case, the Jones case, and those other cases, what we argued is that the defendant created a foreseeable zone of risk by continuing the pursuit when it should have stopped the pursuit. And his fleeing and eluding was intentional. Now, I'm not saying that just because he was fleeing and eluding that was in and of itself an intentional tort. I think you have to look at it in its totality and to the degree that it went to. Even according to the sheriff's testimony, when Robert McLeod, who is the intentional tortfeasor in our opinion, started off by jumping over a sidewalk and driving onto the street in excess of the speed limit. He made a right, and in what I believe was in contrast to his report, he said that he rolled through stop signs, meaning that he was putting on his brake. It appeared to the officer that he was looking both ways and going through the stop signs. Now, if he got in an accident at that point, I think that there would be a better argument on behalf of the appellee here that, hey, he was just rolling through a stop sign, he was stopping. That in and of itself was just plain negligence. But when it got to the point where he was driving in the residential neighborhood going 25 miles an hour over the speed limit and then running through a stop sign without braking, it was at that point it became substantially certain that he was going to cause harm or injury to someone else. Because in that particular intersection, it's a 55 miles an hour for the County Road 44 and only 25 with stop signs on both of the other sides.
I'm troubled by what our standard of review is on that, because that smacks a lot of a factual issue. So I don't know whether we're supposed to look at whether the trial judge erred as a matter of law or whether it's an abuse of discretion. I mean, is the trial judge making a determination about the speed that the fleeing felon goes through the stop sign, or how does that work for us?
I think it all stems from the question of law is whether the intentional tortfeasor was put on the verdict form.
Well, you got to get back one step from that.
Right. And one step from that is the determination of whether he's an intentional tortfeasor.
Who makes that determination?
And I think that has, based upon the case law in the D'Amario case, I think it is the court that makes that determination as to what.
See, that sounds to me a whole lot like a factual determination.
Counsel, I think the problem that we're having on that issue, there are clearly some torts, some actions that might be intentional. I had a case for example, where someone shot another person in a robbery. I mean, I don't think there's any dispute there in the negligent security case that that person, the shooter, was an intentional tortfeasor. I think this case presents a closer question. Some people might look at it as he intended to flee and did so recklessly. Some people could view it differently at different points in the proceeding. And I think what Judge Monaco is trying to get at is, you know, if it's a close question, should question number one on the verdict form, for example, be, you know, was the conduct of the fleeing driver here intentional or merely negligent? Because I think that would kind of then drive how you construct the verdict form from that point on.
Right, Your Honor. And in hindsight 2020, I would have tried to have something like that done if that, you know, it was going to come to this, that there was going to be a question of whether, you know, in trying the case and being the person that tried it, fleeing and eluding, the officer even testified that he thought the guy was intentionally fleeing him. Which,
But that really isn't the key, is it?
it's not. Absolutely not. And so, but, you know, in the mind when I'm arguing whether it's an intentional tortfeasor or not, in the cases that I had, it seemed clear to me that he was an intentional tortfeasor, but then reading into DeMario, it kind of says that it's a matter of degree when the negligence becomes intentional. And so I can't say, you know, I can't completely disagree with you, Your Honor, that it could possibly be a factual question with respect to whether he's an intentional tortfeasor or not. I mean, but that's, I believe that based upon the circumstances presented, that it was clearly an intentional tort.
Does the DeMario case say that it's a question of law? Or does it not speak to that particular issue at all?
It doesn't really speak to that particular issue.
Do you have any decisional law that addresses the issue of whether a driver who is driving, let's call it recklessly, okay, is committing an intentional, whether that constitutes an intentional tort or an intentional act? I
do not, Your Honor, but on the flip side,
and whether or not that's a question of fact or a question of law.
Your Honor, I do not have a case on that. I could not find any case on point of that, but I have the cases in the opposite, which I cited in my brief, are the actual police chase cases. I mean, in every police chase case, there is a question of, they weren't raised with a Fabre defendant, but that, you know, some of them, they're trailing the person for 25 miles, the person is blowing through all the stoplights and finally runs another stoplight and kills someone. And the Fabre defense wasn't raised in that. I guess maybe because it was raised at the trial court level, and the trial court said, no, you can't put them on the verdict form because it was the guy was intentionally fleeing. So I think those cases are just as important for what they don't say as for what, you know, is there a case directly on point on that? I mean, because I believe in the big scheme of things, if this is allowed, you know, knowing now that there is a factual determination as to the degree, you know, going forward, if it's set forth, then we'll know what to do. But based upon the other cases, that the other police chase cases that didn't have anything, you know, that laid out what, you know, if any negligence, you know, comparative negligence you could put on the actual driver.
If it is a question of fact, do you concede that it was properly on the verdict form for the jury to decide? I mean, doesn't the jury, if it's a question of fact, doesn't the jury have to decide whether it is negligence or an intentional tort?
If that is a question of fact, and the ruling is today that there is a question of fact, then I would say yes. I mean, because if it's a matter of law, which we still think it is, I still think it's because making the decision if the person goes on the verdict form, it's almost like you'd have to have that question answered by the jury before you submitted the verdict form. And then, you know, it would, I think you almost have to have it to try your case.
It's one of the difficulties with Fabre, no question about it.
What's that?
It's one of the difficulties with Fabre, there's no question about it.
Yeah, because I think it would be difficult to, at what point in time, because, you know, even if you're opening it, are they allowed to allege that McLeod was, you know, the intentional tortfeasor, if it's determined that way, is at fault for the accident? And they allege that in their closing.
Do you agree that there are some cases where the conduct of the alleged Fabre defendant is clearly intentional, in which case he shouldn't go on the verdict form. And there are other cases where it's at least a question that could go one way or the other.
I would say yes.
And if it's one of those cases where it goes one way or the other, if the jury finds that his conduct was negligent, he's a proper Fabre defendant. If the fact finder says, no, it was an intentional conduct, he's not. Wouldn't that be an appropriate matter for the jury to decide, essentially as question number one? In viewing the conduct of Mr. So-and-so, do you find that his conduct was negligent, or do you find his conduct was intentional or willful?
In hindsight,
That sort of then drives which line you go down.
I think it makes it would make the issue much clearer for sure, and I would agree with that. I mean, to illustrate your point, if someone is intentionally driving 15 miles an hour over the speed limit and gets into an automobile accident, I don't think you can say that that person committed an intentional tort that they should be excluded from the verdict form. That's just mere negligence. So I think that's something like you said, if you presented that to the jury, is that intentional or is it not? They probably would check yes, but I don't know if, that's why I think it's a question of law also.
You have a little less than 5 minutes left, but let me ask another question. Are we supposed to determine in this instance whether the trial judge, whether the decision by the trial judge to put the tortfeasor or the fleeing felon on the verdict form, are we supposed to determine whether no reasonable trial judge would have put that name on there, or do we have some different standard of review?
I guess, Your Honor, the way that the question is presented, I almost have to say yes. That is what we're asking you to do.
Which part of that?
The part that is the determination that
no reasonable trial judge
would say that's not,
okay.
Because
that's the abuse of discretion standard.
Right.
And if it's, I don't quite understand how this can be a question of law and we judge it by an abuse of discretion, and that's one of the difficulties I'm having with this.
Right, and I think that some of the confusion is, Your Honor, is that it's the argument of law is that the intentional tortfeasor shouldn't have been put on there, and I think what the issue now has become is that is the person intentional or not? So therefore, I think when you're going, if the issue becomes that, then yes, it does become somewhat of a factual question based upon the DiMario case.
And that we believe that. You want to save the rest of your time, Counsel?
Yes. Thank you.
I will ask the appellee then to come to the bench.
May it please the Court. My name is Linda Winchenbach, and I represent the sheriff in this case. Your Honor, there's no reason that the actions of Mr. McLeod in this case can't be both intentional and negligent. And
well, wait a minute. Which actions are we talking about?
the fleeing from the deputies.
That's pretty clearly that's intentional.
Right. I'm not sure it's an intentional tort, but it's intentional action. And then running the stop sign and hitting Ms. SZLASA is a negligent act on his part. Now, the definition of an intentional tortfeasor in the DiMario case is, of course, someone who clearly intends the injury, or someone who takes action that is substantially certain to result in injury.
So if you have an individual fleeing from a police officer at a high rate of speed, blowing through, and I'm not, again, talking about this case specifically.
Yes, sir.
But you have an individual fleeing from an officer who's clearly pursuing him, lights and siren, and he's going at a high rate of speed in an inappropriate place, blowing through stop signs and traffic control devices. Your view is that that's negligence and not an intentional tort?
Your Honor, yes, it is.
That's one of the most amazing answers I've ever heard.
Well, I'm going to continue.
And I've got to tell you that, that sort of thing really damages the rest of your argument, that you could say with a straight face that that is negligence?
Your Honor, the fleeing is intentional. The ending up hurting someone because of that is not intentional.
Did you hear the second part of what you just told me before? The conduct either intends to
Substantially certain.
right, or is substantially certain to cause injury. So if I'm driving 100 miles an hour through a crowded school zone with a policeman chasing me and there's little kids crossing the road, then you think that it's just mere negligence when I run over 10 or 15 kids?
No, Your Honor, I'm not saying that.
Well,
That-
tell me more
I think
clearly.
that would rise to the level of substantial certainty.
Okay, so now if I'm driving 100 miles an hour down a road where there are pedestrians with a police officer in hot pursuit and I'm running 10 stop signs, not stopping, and I collide with a car that has the right-of-way, that's not intentional, because it's not reasonably likely that I'm going to cause injury to somebody.
Yes, sir. Under the...
Wait a minute. Yes, sir,
under
that
the-
is intentional, or yes, sir, that's just negligence?
That's negligence. Under the
Did you,
facts...
did you,
under the
did you
facts-
take torts in law school? I mean,
Yes,
that's
sir.
just amazing. I mean, I'm really, frankly, I can't get past how it's harmless in this case, given the fact that they said no to the first question. But I got to tell you, that's one of the most amazing answers I've ever heard.
Your Honor,
Counsel, let me ask you this question
Under-
here. I think you've probably
sorry.
done as much as you can do with Judge Orfinger. The question of whether, during these scenarios, whether the actions constitute an intentional tort or whether they constitute negligence, is that a question of law or a question of fact?
Your Honor, I think that's a question of fact. I think
You got
whether-
anything other than your own, view of the law on that? I mean, do you have any authority for that?
No, Your Honor, I don't.
Did anybody
I didn't
research
find
that?
anything that addressed that. The cases say that whether to put a defendant, put a person on the verdict form as a Fabre defendant is a question of law for the judge, that the named defendant has to present evidence and so forth. And that's what the judge did in this case. He considered the evidence that had been presented, and he said that McLeod, the fleeing felon in this case, had committed a separate act of negligence.
Can you negligently commit a felony?
Excuse me?
Can you negligently commit the felony of fleeing and eluding? I mean, you just told me he's a fleeing felon. Your officer arrested him for fleeing and eluding, is that correct?
Yes, sir.
Can you negligently commit fleeing and eluding? Isn't that, under the law, isn't that willfully fled from a pursuing officer when a reasonable person would have known that the lights and sirens and horns and everything meant pull over?
Yes, Your Honor. The fleeing was clearly intentional.
And so the conduct that was reasonably likely to flow from that, somehow there's a break in the chain of causation. That's your theory?
Yes, Your Honor. Under the definition that the DeMario court has set out, and also based on what the Spivey court has said, the reckless or the knowledge that something is risky is not an intentional tort. For an intentional tort, there has to be substantial certainty. This chase, in this particular case, was not like in the Brown case where it was almost like the Wild West, I think the court said,
I'm certainly willing to
this man was slowing
concede.
down for stop signs.
I'm willing to concede that there are some chases, you know, I think we all remember the O.J. Simpson low-speed chase.
Yes.
I don't think that was, if the officers just sort of followed him along at 20 miles an hour for 100 miles, I don't think that was reckless conduct on anybody's part there. And so I think, that he might be a proper Fabre party if a collision occurred. But on the other hand, the fact that you're unwilling to concede that if a guy's going 100 miles an hour through a school zone and runs over a bunch of kids, that's not an intentional tort likely to cause injury, I just find astounding.
Well, Your Honor, what you're asking me about in the other scenario would likely still be a factual question.
So you think if a judge granted a directed verdict on your Fabre defense, when the facts were that saying he was an intentional tortfeasor for driving 100 miles an hour through a school zone with a bunch of kids present, that you would argue that ought to be reversed?
I'm sorry, he had granted a directed verdict? No.
Good. If that case comes up, I think you should hope I'm not on that panel.
Yes, sir.
Why don't you respond to counsel's argument that it is a harmful error, and he makes two arguments. One is that the question one was kind of a compound question. It addressed, on the one hand, negligence, which is duty and breach of duty, and on the other hand, causation. The jury might have thought that there was, a duty and a breach of duty, but there wasn't causation. And then the second argument he makes is that the whole trial was tainted because that issue was essentially properly argued to the jury since it was on the verdict form. How about addressing those both?
Your Honor, the jury instructions, the jury was given the standard jury instructions, and there was discussion, sidebars with the judge, and the plaintiff's attorneys
I'm not asking you to comment on whether the jury instruction was proper. They haven't raised that issue on appeal. As I understand your argument, you say that even if the Fabre defendant should not have been on the verdict form, it's a harmless error because the jury returned a verdict of no negligence,
Yes,
which
sir.
he just gave you the retort that I hope I've given
Yes, sir.
credit to his argument. I'd like you to respond to that directly, if you would.
Your Honor, that could be said of just about any case where there is a Fabre defendant. There's always the chance that the jury is going to say, well, we've got another person here that's probably 100% negligent, so this first question has got to be no, they couldn't be negligent. That's not something that's peculiar just to police chase cases. To allow an exception for an intentional tortfeasor would essentially swallow up
If
statute.
he's right that it shouldn't have been on the verdict form, is it harmless error and why?
If he's correct that it should not have been?
If he's correct that it should not have been on the verdict form, is it harmless error, and if so, why?
Because under the facts of this case, the jury had competent substantial evidence to find that the sheriff's office was not negligent. We've already discussed the circumstances of the case, that it wasn't, there weren't egregious actions by the sheriff's deputies. It wasn't a wild scenario, and there's no reason to think that the jury's determination was not supported by the facts that were presented to them. And it shows a lack of faith, basically, in the jury's ability to understand the instructions and to look at the verdict form and make what would be a proper assessment of negligence. They didn't have opportunity to reach causation and comparative negligence in this case. And so on that basis, yes, we do say that it was harmless that McLeod was on the verdict form.
Anything else, counsel?
Well, Your Honor, I would just like to emphasize that it's our position that Mr. McLeod was not an intentional tortfeasor, that his conduct had aspects of intention and also aspects of negligence, and that there is no basis for saying that his intentional act turned his negligent act into an intentional one. And the trial judge had heard the evidence at trial and decided that he was an appropriate Fabre defendant. If he decided that in error, then again, it's our position that it's harmless error because of the jury verdict. They never reached the question, at which point the fact that there was a Fabre defendant on the verdict form would have become important, and the order on appeal should be affirmed.
Thank you, counsel.
Thank you.
Mr. Lynch, you have 3 minutes and 26 seconds.
Thank you. First, I want to address what you were just talking about with the harmless error. In the trial of this matter, when they were speaking of McLeod, they talked about what he was allegedly wanted for in that bolo, to be on the lookout for. Although there's a lot of factual disputes that I could talk to you about, that they really didn't know that he was wanted for a strong-arm robbery. When they were presenting the case at the end, they were talking about how they were pursuing a strong-arm robber, a person that robs elderly ladies and takes their purses, and that they had to get this guy. So I think when you say it's harmless error that this guy was on the verdict form, they made him out to be a bad guy. He was convicted of felony, fleeing, and eluding, which, by the way...
I really don't see any way you're going to get around all that coming into evidence, even if you retried the case. I mean, the sheriff's going to be able to testify as to the facts and circumstances, and the jury's going to have to make a judgment as to whether or not they were negligent. So that all is going to come into evidence, isn't it?
Agreed. But when you're able to, at the end of the trial, put the blame on that person, it's obvious he ran the stop sign, was speeding, and caused this accident. So I think that, absolutely, I think all that stuff would still come in, but I think it prejudices us in our argument that they're allowed to put that, what we believe to be an intentional tortfeasor on the verdict form so that the jury could consider that, see his name on there, and say, we can blame this guy. The law is clear that when in Fabre, you're talking about two negligent tortfeasors combining to come to one harm. What we argue in this case, Your Honor, is that there's two separate negligent acts. One separate negligent act of the police, and that was to continue the chase and create that foreseeable zone of risk. So therefore, and his acts in and of himself of fleeing and eluding was separate. That's a separate intentional act, which we argue. Therefore, you cannot combine those two. And that's clearly stated in the Jones case that says that, in Fabre, addressed the combined negligence of two drivers. And then talking about narrow crossings, in the Jones case, the Supreme Court has explained that negligent acts are fundamentally different from intentional acts. So we think that would have confused the jury, even if the jury did do their job and read the jury instructions and understood them. I think it would still confuse them having McLeod on the verdict form as an intentional tortfeasor. And if there's any more questions, Your Honor,
Thank you, counsel.
Thank you for your argument.